How we roll it, folks. This now is a Fox News alert, and reading this. The U.S. Supreme Court rules in favor of former President Donald Trump in his appeal of a Colorado ballot disqualification. That applies to Colorado. In all likelihood, it will apply to other states as well. Live to Shannon Bream for her initial analysis and reaction now. Did you have the inside word, Shannon? Hello.
Okay. So what we have from the court this morning is this decision in favor of President Trump. They essentially say the judgment of the Colorado Supreme Court that he could be kicked off the ballot in this manner does not stand, has to be overturned. Now, it's a per curiam opinion, which the Latin for that is sort of the court speaks. It's supposed to be sort of a unified voice. But we do, as I'm looking through here, some additional folks who wrote, Justice Barrett, and I believe Justices Sotomayor, Kagan, and Jackson. They write concurrences as well. So they may have gotten to this in a different way, but I don't see any dissents here. So it sounds like the court as a whole is agreed that whatever happened with Colorado, it was not the proper framework to use here. There is discussion at the end of the main decision that says, you know, there would be essentially a patchwork across the states. This was one of the worries that the justices had, and the questions that came together in argument were, what happens if we tell one state they can do this? The Chief Justice said, what if one state decides, okay, I'm kicking off a Republican, another state says, okay, I'm kicking off a Democrat, and then we get down to just a handful of states that actually have all of the candidates' names on the ballot. What would that do to this country? So it sounds like the majority of the court has come together in this voice to say what happened in Colorado is not correct. It sounds like they're saying states don't have this power, but essentially this is something that should be left to Congress. And so they agree to that point, but how they got to these different positions, how they got to the agreement, they found some different maps there, but they got to the same end result.
Okay, Shannon, I'm going to show our viewers this map here, guys, if we could. I hope I've got the numbers right. Correct me if I'm missing a few. It appears that at least 9 states, all right, this applies to Colorado, but Illinois has a similar charge, so does the state of Maine. Maine is in Super Tuesday tomorrow. And then everything you see in yellow has a case that's pending. Does this nullify all of those, or some of those, or none of those?
Well, if you're asking me, I think we'd all probably agree that these states have lost their ability to do this, but I'll let my fellow panelists.
Okay, all right, Professor Turley, is it all these cases done?
I think they're all dead as Dillinger. I mean, when you read this opinion, there is no dissent that the states cannot enforce the 14th Amendment provision. The only disagreement, as we've been discussing, is whether the court should have gone even further to sort of close off future arguments or challenges without an action from Congress. The majority is saying that, look, you need Congress to act here before you can enforce this provision. Some of the justices felt they really didn't have to deal with that question. They didn't say, by the way, that they disagree with the conclusion necessarily, as much as that is a bit of a reach beyond where they need to go. And the dissent is saying, look, we have a long tradition of minimizing our footprint, of trying to stay confined to the question at hand. That's not much of a disagreement. You know, you keep in mind that for months now, this has been literally called an unassailable theory. Various professors and columnists have been saying that the only thing that will stop the disqualification of Donald Trump are the conservative justices acting as political robots. Well, this is a unanimous court rejecting that unassailable theory.
Duh.